This is a judgment which the court promulgated during the summer recess on 18th August. The appeal raised an issue as to whether and in what circumstances a party to a contract can set aside the contract on the ground that it was entered into as a result of the other party threatening to do a lawful act. In lawyers' language, the question was, does English law recognize the existence of a doctrine of lawful act duress? Times Travel, a travel agent in Birmingham, sold tickets for air travel between the United Kingdom and Pakistan. It had a strikingly one-sided contractual arrangement with what was, in effect, its monopoly supplier, Pakistan International Airline Corporation, which I will call PIAC. PIAC allocated tickets to Times Travel and paid it commission for the tickets which it sold. PIAC had the contractual right to terminate the arrangements by giving 1 month's notice. Times Travel's business depended upon its contract with PIAC. A dispute arose between PIAC and a number of travel agents in which the agents alleged that PIAC had failed to pay them certain commission payments. Some agents brought claims against PIAC for the recovery of the unpaid commission. Under pressure from PIAC, Times Travel did not join those legal proceedings. PIAC sought to get its agents to accept a new arrangement which altered the terms on which it paid commission. In September 2012, PIAC, as it was legally entitled to do, cut Times Travel's fortnightly allocation of tickets from 300 to 60 tickets and, as it was entitled to do, gave notice that it would terminate its agreement with Times Travel at the end of October. The termination of the contract would have put Times Travel out of business. So Times Travel accepted the new agreement which PIAC preferred. One condition of the new agreement was that Times Travel waived any claims which it might have to previously unpaid commission. One of the directors of Times Travel had been shown a draft of this agreement a few days before it was signed, but PIAC had refused his request to take a copy of the draft in order to discuss it with colleagues and obtain legal advice. Times Travel thereafter brought a claim against PIAC for unpaid commission under the prior agreement. It argued that it was entitled to rescind the new agreement on the ground that it had signed it as a result of lawful act economic duress. The trial judge agreed that Times Travel could rescind the new agreement, but he also found as a fact that PIAC had believed that it was not liable to pay the disputed commission. The Court of Appeal allowed PIAC's appeal because PIAC had not acted in bad faith in demanding that the claims for commission be waived. Times Travel appealed to this court. This court dismissed its appeal. The court has produced 2 judgments, one by me, with whom Lord Reid, Lord Lloyd-Jones and Lord Kitchen agree, and the other by Lord Burrows. Lord Burrows and I agreed on what are the elements of the doctrine of lawful act economic duress, which would entitle a party to have a contract set aside. Those elements are, first, that the threat or pressure exerted by the defendant must have been illegitimate. Secondly, that the threat or pressure must have caused the claimant to enter into the contract. And thirdly, that the claimant must have had no reasonable alternative to giving in to the threat or pressure. The appeal is concerned with the first element, and the question was whether PIAC's threat was illegitimate. On this question, Lord Burrows and I agreed that the threat was not illegitimate, but we adopted different analyses as to what made the threats or pressure illegitimate. In my judgment, which had the support of the majority, it is explained that the English courts have recognized lawful act duress in 2 circumstances. The first is where a defendant uses his knowledge of the claimant's criminal activity or that of a person close to the claimant to put pressure on the claimant by threatening to reveal that activity. This was originally analysed as an example of the equitable doctrine of undue influence, but is now seen as an example of lawful act duress. The second is where the defendant, who has exposed himself to a potential civil claim by a claimant, uses reprehensible means to maneuver the claimant into a position of vulnerability in order to force him to waive his claim. In both circumstances, the courts have been influenced by the role of equity, and the idea of an illegitimate threat or pressure is closely aligned with the equitable concept of unconscionability. This does not make judges the arbiters of what is morally or socially acceptable. The courts have identified specific contexts in which equity intervenes to protect the weaker party. It will be rare for a court to find lawful act economic duress in the context of a commercial negotiation. This is because English law does not have a doctrine of inequality of bargaining power or any general principle of good faith in contracting. Other jurisdictions are similarly cautious in declaring hard-nosed commercial behaviour illegitimate. While PIAC's behaviour in giving notice of termination of the previous contract and in cutting Times Travel's ticket allocation may appear hard-nosed, it is not reprehensible in the sense used in the case law. The fact that PIAC believed that it was not liable to pay the claimed commission further supported the view that its behaviour was not reprehensible in this sense. Lord Burrows concurred in the conclusion that Times Travel could not rescind the new agreement, but his analysis of what made a threat illegitimate differed from that which I have articulated. The question to him was whether the demand was unjustified. A demand would be unjustified and the threat illegitimate if, firstly, the threatening party had deliberately created or increased the other party's vulnerability to the demand, and secondly, the demand was made in bad faith in the specific sense that the threatening party does not genuinely believe either that it is owed what it is claiming or that it has a defence to the claim against which it demands a waiver. In his view, Times Travel's claim for lawful act economic duress failed because PIAC believed it was not liable to pay the claimed commission. While the reasoning in the two judgments differed in these respects, the court was unanimous that Times Travel's appeal should be dismissed.